On December 4, 2025, the DOJ formally launched what it calls the Second Amendment Rights section within its Civil Rights Division. The Civil Rights Division is historically responsible for enforcing laws that protect fundamental constitutional protections, voting rights, freedom from discrimination, religious liberty, and free speech among them. Placing Second Amendment enforcement within that same division sends a clear message. Firearm ownership is being treated not merely as a regulatory issue, but as a constitutional civil right on par with other enumerated freedoms. That structural change matters. When a right is enforced through the Civil Rights Division, it signals active federal oversight of potential violations by state and local governments. Early lawsuits. Where the DOJ is acting. The new section did not remain symbolic. It began filing lawsuits soon after its creation. Among the first targets, Los Angeles County, the U.S. Virgin Islands, the state of Hawaii. Washington, D.C., permit delays and concealed carry. In Los Angeles County and the U.S. Virgin Islands, the DOJ is challenging concealed carry, permitting systems that allegedly involve multi-year processing delays. The argument is that excessive delays amount to a constructive denial of the right itself. The DOJ's position appears to be that if a government provides a permitting pathway but administers it in a way that makes approval practically unattainable, that system may violate constitutional protections. In the Virgin Islands, additional requirements such as home inspections have also drawn scrutiny. The DOJ contends that such measures raise constitutional concerns when tied to exercising a fundamental right. Hawaii's sensitive places restrictions. In Hawaii, the lawsuit challenges laws that limit where licensed carriers may lawfully carry firearms, particularly on private property without explicit permission. Critics argue that such restrictions, when combined with broad public sensitive place designations, effectively eliminate the practical ability to carry. The DOJ's legal theory appears grounded in recent Supreme Court precedent, emphasizing that restrictions must be consistent with historical tradition. Washington, D.C. and AR-15 restrictions. The DOJ has also taken aim at certain rifle restrictions in Washington, D.C., including bans affecting AR-15-style firearms. This marks one of the first times the federal government has affirmatively filed suit arguing that a jurisdiction's firearm restrictions violate the Second Amendment rights of residents. The executive order that sparked the shift. This new direction traces back to an executive order issued on February 7, 2025 by President Donald Trump. The order instructed Attorney General Pam Bondi to review federal actions between January 2021 and January 2025 that may have infringed on Second Amendment protections. That review reportedly included DOJ enforcement policies, ATF rulemaking and classifications, federal grant programs, interagency coordination efforts. The goal, according to the order, was to identify policies that could be rolled back or revised to align with constitutional interpretations favored by the administration. The closure of the White House Gun Violence Office. One of the most visible changes involved the closure of the White House Office of Gun Violence Prevention, originally established during the Biden administration. The office had coordinated federal efforts on gun violence policy and grant distribution. Critics argued it functioned as a centralized policy hub for expanding firearm regulations. Supporters viewed it as a necessary response to rising gun violence rates. Its closure signaled a clear policy reversal at the executive level. ATF enforcement changes. The Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF, has also seen shifts in enforcement posture. During the previous administration, the ATF implemented a zero-tolerance policy under which certain paperwork errors by federally licensed firearms dealers, FFLs, could result in license revocation. The current DOJ has replaced that framework with what it describes as a more proportional administrative enforcement model. Dealers previously affected have reportedly been invited to reapply in certain cases. Supporters say this corrects overreach. Critics argue it may weaken regulatory oversight. Either way, it represents a tangible change in enforcement philosophy. National Firearms Act (NFA) tax changes. Another significant development involves the $200 tax stamp required under the National Firearms Act (NFA) for certain regulated items such as suppressors and short-barreled rifles. Congress eliminated the $200 tax effective January 1, 2026, through budget legislation. However, the underlying NFA regulatory framework, including registration requirements, remains in place. The ATF has reportedly updated its processing systems in preparation for the tax change, anticipating increased application volume. This creates an unusual legal situation. The NFA was historically justified in part as a tax measure. With the tax removed, constitutional challenges may intensify. Red flag laws, a state-level battle extreme risk protection orders, ERPOs, often referred to as red flag laws, remain active in 22 states and Washington, D.C. The current DOJ has not filed direct challenges against these statutes, but has publicly expressed concerns regarding due process protections in certain implementations. Meanwhile, some states, including Montana, Oklahoma, Tennessee, Texas, West Virginia, and Wyoming, have enacted laws prohibiting red flag mechanisms. Others have expanded them through legislation or ballot initiatives. Because ERPO laws are primarily state-level statutes, their future will likely be shaped by state courts and federal appellate review. The Supreme Court factor. Much of the long-term impact will depend on the Supreme Court of the United States. Several major Second Amendment cases are percolating through lower courts, including challenges to magazine capacity limits, assault weapons bans, sensitive places expansions, felon in possession prohibitions. The Supreme Court's 2022 Bruen decision established a historical tradition test for firearm regulations. How lower courts interpret and apply that standard remains contested. If the court grants certiorari in one or more major pending cases, nationwide precedent could shift significantly. A complicated reality. While the DOJ has moved aggressively in certain pro-Second Amendment directions, it continues to defend aspects of the National Firearms Act in ongoing litigation. It has also accepted amicus briefs from gun control advocacy organizations in certain cases, illustrating that institutional legal defense of existing statutes does not always align perfectly with broader political rhetoric. In other words, the situation is nuanced. Federal policy may be shifting, but not uniformly across every issue. State-level development's firearm law continues to vary widely by state. New Jersey is litigating sensitive place expansions. New Mexico saw its waiting period law struck down. Missouri's attempt to restrict state cooperation with federal enforcement faced federal challenge. Virginia's recent elections signal possible expansion of state-level gun control measures. For gun owners, this reinforces a key point. Federal shifts do not automatically override state law unless courts invalidate those statutes. The bigger picture. The establishment of a Second Amendment rights section within the DOJ marks a historic structural change. It indicates that, at least for now, federal leadership views firearm rights enforcement as a civil rights priority. However, red flag laws remain active in many states. NFA registration requirements persist. Supreme Court outcomes remain uncertain. Future administrations could reverse course. Constitutional law evolves slowly through layered precedent and shifting political leadership. Final thoughts. We are witnessing a significant chapter in Second Amendment jurisprudence. The DOJ's new posture could influence lower court decisions, embolden legal challenges, and reshape federal-state dynamics. But no single administration permanently settles constitutional debates. These issues will continue to move through courts, legislatures, and elections. If you follow firearm policy, the key is staying informed through reliable legal sources, tracking court developments, and understanding your own state's laws. The next year could bring major rulings that clarify or complicate the legal landscape even further. Whatever your perspective on gun policy, this moment represents a notable shift in how the federal government approaches one of the most debated constitutional rights in America.